This is Velasco, case D-03-1190. State your appearances. You're Monique Velasco. All right.
Morning, Your Honor. Doug Crawford on behalf of Tony Velasco, appearing for Mandy McKellar. Bar number 181. Mr. Velasco's present. Have a seat, sir.
All right. And this is defendant's motion for a change of custody, modification of child support.
It is, Judge. There are two minor children. Dakota, age 13. Sequoia is a little girl. She's age 9. The motion's filed pursuant to Ellis versus Carucci. The material change in circumstances being twofold. Number one, the series of domestic battery incidents that occurred, at least one in the presence of the children. But worse than that, the fact that the plaintiff chose to reconcile and continue living with the serial batterer. So we're arguing that that's the change in circumstances for the kids. From 2012 until about December of 2014, there were a number of violent incidents. At least some of them occurred in the presence of Dakota, which caused him emotional trauma. Now,
Is it Dakota or Dominic? I have Dominic as the child.
Dakota, I think, was the one that witnessed. Or what's that?
Dominic is his first
Dominic.
Oh.
It's Dominic and Sequoia.
Oh, I'm sorry, I had it wrong. Dominic. And the reason that we know this happened is because the plaintiff's own words, damn her, she filed a temporary protective order under oath, alleged numerous domestic battery incidences. She then filed a custody motion of her youngest child, Justin Jr., again, verified that, signed that in front of a notary as truth, and went into great detail about these battery incidences and great detail about the emotional trauma that Dominic suffered, and then continued and went ahead and reconciled with Justin. So, I mean, the question, this is the old law school conundrum, was she lying then or is she lying now? So the kids have expressed to Dad that they're just uncomfortable being with this guy. So we're going to ask for a change in custody. We think the kids should be interviewed. And what we're asking is that the timeshare be switched. Right now, Dad has what days?
Monday, Tuesday, and some Wednesday.
Monday, Tuesday, and Wednesday you take him to school?
Yes.
But I think Mom's days off are Wednesday and Thursday. So we're okay with Mom having Wednesday night, Thursday night, taking the kids to school on Friday. We'd ask that there be no contact with Justin, ask that the kids be interviewed by FMC, send the parties to mediation to mediate a final solution, a final resolution, child support of 25%, fees, and set the matter for an evidentiary hearing.
All right. Ms. Velasco.
So, yes, in fact, I have reconciled with Justin, and yes, in fact, I did go through a very contested custody battle. I filed a restraining order in December against Justin. The restraining order ensued. There is a lot of inconsistencies in Mr. Velasco's motion that was filed, and when I filed my response, I tried to correct a lot of those. I have been in a relationship with Justin from 2012 to 2015 currently. Mr. Velasco, during the duration of the relationship, was aware of my relationship with Mr. Day. I had several times that I communicated with him about what was going on in my relationship. I actually communicated and called him several times. In 2014, I checked my son into therapy to try to be proactive. The therapist did not recommend any further sessions with him. I was taking precautionary measures. I informed Mr. Velasco of said therapy sessions. The therapist had stated that it was just an adjustment. I kept monitoring him for anything else that had happened. His grades he's been in extracurricular activities. Both of my children have been in extracurricular activities that I pay for. They go 3 to 5 times a week that I drive them to, take them to. Both of my children have A's and B's in school. And even despite my reconciliation with Justin, who I've taken every precautionary measure. From the moment I filed the restraining order on him in December, Justin commenced custody a custody battle with me over our 18-month-old. At the time, I believe he was a little younger than 18 months old. Justin commenced a custody, but asking for joint custody. I retained counsel. He retained counsel. From that moment on, I was under counsel's advisement. He was under counsel's advisement, and we kicked it over to family court. My case was heard in front of the Honorable Judge Duckworth. Duckworth was able to see everything that was filed. We testified. We had testimony. Judge Duckworth, after hearing everything, found Mr. Day fit and proper of an 18-month-old child. He was granted joint custody, physical and legal. And it's very hard for me to understand how an 18-month-old who does not have communication, does not have phone access, does not have any of the necessary things that a 13 and a 9-year-old have, would get joint custody of somebody who was not fit and proper. I pay for cell phones for both of my children. Mr. Velasco has complete and total access and communication to both of them. There is never in the duration of my relationship from 2012 to 2015 been any communication from Dakota or Sequoia in regards to any violence, in regards to any unsafe measures, in regards to any situation that's risen. There's been no CPS reports. There's been no filing of any police reports. He's not done one thing to protect his children from Justin. And in fact, upon reconciliation in June, I sat down and had communication with Mr. Velasco, and I told him, Justin and I are going to try and work things out. We went through our custody battle when we were able to finally speak, which we weren't able to speak or talk. I was going through domestic violence counseling from January 2015 to May of 2015. I saw a counselor bi-weekly. I was able to learn different safeguards, learn how to deal with situations, learn how to do anything I needed to. The moment that Justin and I reconciled, we checked ourselves into couples therapy. We've been doing that every 2 weeks. We are seeing Sarah. We've done at least 6 sessions, and we are going to continue going. After I had let Mr. Velasco know about my reconciliation with Justin, that was prior to Father's Day. I let him know that there was going to be a reconciliation. On Father's Day, there's text messages that I produced as evidence. He refused to pick his kids up on Father's Day, did not want them in the daytime, and I had told him that I had expected that he would be picking up the children on Father's Day. He had claimed that he had no plans and didn't want them. I expressed, this is all produced in one of my exhibits, I expressed that my father had already left and that Mr. Day would have to be watching the children. He said, I'll see you tomorrow. So now this is somebody claiming that Mr. Day is unsafe and is not capable of being around my children. He wants a no-contact order, but on Father's Day, after our reconciliation, he knew that Mr. Day was going to be watching his children. 3 days after that happened, I got a letter from him stating that he did not want Justin around my children and that I needed to take precautionary measures. That exact weekend, I offered him to pay for a babysitter, and I says, I understand your concerns. You're more than willing to pay for a babysitter. He denied paying a babysitter and said, I'll just deal with this later. Didn't pay for a babysitter, so rather than having to deal with any confrontation with him, I allowed him to take the children that weekend. I didn't want to make him upset. I wanted to make him feel comfortable with the situation. He took both of my children Friday, Saturday, and Sunday, which is my custodial time, so he could feel better about the situation. I found out when I picked up the children on Monday, I believe, or it was Wednesday, excuse me, I was not able to communicate with them at all. The cell phones that I pay for, I had a terrible time communicating with my children. They weren't responding to me. He was claiming the phone was dead. And it was very hard for me because I wanted to know what was happening to them. That was the first time in 10 years I had actually given up my custodial time to him. I don't give up my custodial time. In fact, Mr. Day and Mr. Velasco in the past have worked together when he's had issues with his custodial time, and Mr. Day has actually taken over and ran the kids to practice and participated in these activities, and he's forfeited his time to Mr. Day. Just like on Father's Day, which is his day, he forfeited, and this is after the reconciliation, after the custody battle, after everything had happened. So now I acknowledge his letter, acknowledge his concerns, give him the children. I'm not able to communicate with them at all. They get back, and my kids tell me, all right, we were a little bit uncomfortable. We were in 3 different homes for that weekend, 3 different sitters. He was picking them up at 2:30 every night because he gets off at 2 in the morning. And the third night, he ended up spending the night. Now, I know this because he has a younger son with his current girlfriend, and they often leave that child at the sitter so they can go out and be adults for the night. I was not comfortable with that situation any longer, and I said, okay, that's not good for the kids. I'm just going to keep them, and Mr. Day's going to be watching them. At that point, if there were problems, he should have commenced something against me. That didn't happen. So that happened in June. I had no further communication from him. None. The whole entire summer. For 10 years, we've been able to co-parent. 10 years. I give him time. He gives me time. It's worked so extremely well that I think, I had to take that COPE class, and I was watching the video, and I was thinking, oh, this is me and my ex-husband. People admire the relationship we have. He's watched my kids, my son, my 18-month-old. I've watched his son, which in fact led to another situation, which domestic violence is an issue. Justin's not had anything ever filed on him. Nothing's ever been charged with him. So there are inconsistencies in their statement. But Mr. Velasco here did, in fact, have a domestic violence strangulation issue that the DA took over and was later dropped by his girlfriend. So it's very interesting to me that he wants to pursue this when he has that on his record.
Mr. Crawford, you'll have a chance to respond. Go ahead.
So he had that against him, and I was completely unaware of that situation, that it ended up being pursued. But I did witness that myself because it happened at my home the day I watched their younger child. So I'm very concerned and saddened that we are at where we are right now. Mr. Velasco and I have had an extremely, extremely workable relationship. In the summertime, he asked for extra time. Just as a matter of fact, this past summertime, he had requested time to go to California to play basketball in a basketball tournament and asked if he could take the children. Sure, you want to pick them up on Sunday nights after work? That's great. You can take them. It's more convenient for you. Take them. He was given Sunday, or actually it was Monday morning at 2:30 after he got off work. He picked up the kids, and he started bringing them back to me Wednesday at 5. Our relationship has been like that, and for him to not pursue anything else and claim that there's a safety issue, it concerns me that having my children go through what I went through with Justin and the custody battles are always stressful and everybody involved. For him to do what he's doing right now, it just doesn't make any sense. Like with us communicating and us talking, he sent me the letter. I responded immediately. Like I had said, there was no further communication after that. There was no concerns of safety. There was no concerns for my children. There was no messages to him. There was nothing. Justin and I have tried, based on what our therapist had recommended, that we involve the children because when they come back from their fathers on Wednesday, there's a lot of tension. And I believe, I don't know for sure, but I believe it's that he's been getting into their head about a lot of the things that are going on. So on Wednesdays,
that's pure speculation.
Mr. Crawford, you'll have a right in a minute to respond. Let her finish.
So on Wednesdays, when I would get my kids back, we were doing family activities. There's so many things posted on Facebook, which Justin and my son are tagged, which is also produced in exhibits. They're happy. We're trying to move forward in our life. Like I said, I did domestic violence counseling. Justin and I are doing therapy. Since this has happened, I've checked both of my children into therapy. My son has since been seen by another therapist. It was the same thing. My son went in on his own. This is based on his recommendation. My son went in on his own, spoke to the counselor, called me in afterwards, and the counselor said, okay, I've had a chance to talk to him. It's adjustment. I recommend family therapy, but I do not need to see him again. He's doing well in school. He's socially active. There's nothing wrong with this child.
All right, thank you.
One therapy session to address these issues is simply not sufficient. She has opined that he hasn't done anything. Well, he filed this motion to address these issues.
Did he seek therapy for his child? Did he talk to her about additional therapy? Did he?
They discussed the one session that she got them into, but he thinks they need more, and the reason he thinks that is because the kids have come to him. Both kids came to him and said that they are uncomfortable around this man. Whether there's a safety issue or not, we don't know as we sit here today. Sounds like there was. She was sure arguing that there was vociferously to everybody who would listen not too many months ago.
If we changed custody every time a mom becomes victim of domestic violence, then we'd have a lot of issues here.
At least we need to hear from the kids. Let's hear from the kids. We need an FMC interview to ask them what their concerns are.
I would also note that, Mom, you've made a motion for arrears. You need to file your schedule of
I have,
arrears.
it's in my,
Claiming arrears of $6,679 in child support, plus penalties and interest. So file your schedule of arrears so we can address it at the next hearing.
okay,
I'm not going to make any changes in custody at this time or visitation. It sounds like Mom has taken steps to address any issue that may have arisen. We will refer you, we'll send both children for child interviews regarding the historic timeshare and a general interview. We'll set a hearing date on that. Mom will be able to file her schedule of arrears. We'll address the issue of child support arrears at the next hearing. And since the two of you have been able to co-parent for 10 years, that's unusual. That's very good. That shows a maturity on both parts. By the way, you were very eloquent today. I rarely see attorneys as eloquent as you are.
thank you.
I was going to say the same thing. That was one of the best arguments I've heard in a while.
You did very well.
Thank you.
It sounds to me like both of you are very good at dealing with your children, and I appreciate your concern. I would, if I were in your situation, I would be very concerned too. So I think that maybe having the children interview will help address some of those concerns, and the two of you, since you've worked so well together in the past, can probably work together to see what's in the best interest of your children going forward. So after you've seen the results of their interview, I would like for the two of you to see if you can settle this through mediation. So we'll have them go to Family Mediation Center after they've read the results of the interview, and then we'll come back here. All right?
I noticed that the court said that the interview was with respect to the historic timeshare, but also the
And
interaction.
a general interview. And a general interview.
Okay. Okay.
Okay?
FMC return.
Oh, thank you. All right, there you go.
I have a return date for January 6th at 1:30.
Great. Thank you, Your Honor.
Okay, and they'll need to contact the Family Mediation Center to arrange for the interviews, correct?
Yes.
I'll take both parties over there now.
Okay,
I'll give them a form and they'll check.
all right.
Thank you, Your Honor. Thank
Thank
you,
you.
Mr. Marshall. Thank you.